rise.
Yes, Mr. Steinberg.
My Lord, I'm very grateful for the Court's indulgence, and I will attempt to answer the two questions that were posed to me before the lunch break, which I paraphrase as, firstly, were these methods available to the judge? And secondly, if the Court accepts the appeal in principle, what should the Court then do? If I deal with the first question, the defendant has characterised the appellant's approach before this Court as a new case. We disagree. Our proposed intermediary positions, we say, are simply lesser expressions on the same footing as the full case. And they're lesser expressions because they're looking at isolating that part of the income which related to Mr. Head's work and that part which related to the capital. There is no set method, but following, for the Court to adopt, following Gamble and Ward and a host of other authorities, we suggest the Court must use the materials available to make the best estimate of the loss possible. And if the judge below had asked herself the right question, and then having done so, gone on to reject the height of the full case presented by the claimant, we say that the intermediary positions are merely examples of how she could have assessed what would have been the appropriate discount. My Lords, the second question is what should this Court do if it's with the appellant on the primary points? We respectfully submit that the Court has sufficient material to make an assessment, albeit an approximation, of the loss and that which relates to the working capacity. On the evidence, we submit that the assessment, the best assessment, was the profits that the claimant was able to draw from the business had he so chosen. But if this Court is not convinced that this is an all rather than a nothing case, we submit the starting point must be the judge's findings about Mr. Head's contribution to the business. We respectfully suggest that must be higher than the 50-50 split that was achieved in ADSET. And in fact, we suggest that the vast majority of that income should be attributed to his working capacity. And we stand by the 10% figure that was suggested in the replacement skeleton argument at paragraph 105, subparagraph 2, which is at page 46. My Lords, there are also, my Lady, there are also some quantification errors we suggest, which didn't arise given the judge's findings, but they are set out at paragraphs 100 to 103. They mainly relate to the judge accepting Mr. Stanbury's figures, but then in her projection using Mr. Forth's, and that affected both the projected income and the living expenses. They are at pages 45 and 46. They are matters that could be dealt with if this Court were minded by the accountants themselves. My Lords, my Lady, unless I can assist you any further, those are mine.
Thank you very much, Mr. Steinberg. Ms. Bates. Mr. Kent.
Yes. My Lords and my Lady, it would probably speed things up slightly if the Court has to hand my skeleton argument.
Yes.
Avoid me diving too many times into the bundles, because I tried to quote key passages where appropriate. I will come, it's an important point, to some further detail about the nature of this company, because there have been observations made which make it sound as to someone who is unfamiliar with the facts, the detailed facts of this case, as of course the judge was, as though this was essentially a one-man business incorporated for convenience, which might or might not be successfully taken on by his sons. We will see in a moment the scale of the business as it had developed, and of course the the proposition that Mr. Head had achieved a remarkable success in founding and developing a business. The proposition that's somehow inconsistent with the judge's approach that there was no evidence that actually the losses, that there would be a loss of dividend income after he ceased to be in charge of the business. It is not, does not follow as a matter of logic. There are plenty of businesses which have been set up by entrepreneurs, which were entirely due to their own efforts, which have become established businesses, which continue and have their own gravitational pull, as it were. But so it is important to look at what this business is and what was going on. But before I come to that, can I just again, it's in the skeleton. Take the court to the way in which the claim has always been put until effectively the claimant's replacement skeleton argument and my learned friend's oral submissions before the court today. In the defence has been quoted, and I needn't go back to that, paragraph 18.5. And with great respect to what my learned friend says, that put the position perfectly clearly, because one only had to go to Adsit and West and see, which is referred to in the defence, and see that it is important, therefore, potentially, to tease out what is the difference between income, which is a return on capital, and income which is attributable to the claimant's own continued efforts. The initial schedule of loss and the final schedule of loss proceed simply on the basis that there is a claim for the 4.42 million, I think it is, loss in the lost years, based upon Mr. Stanbury's report. There's nothing else said, no alternative put forward. The counter schedule has been referred to, and can I just take you to a bit more of that in tab 6 of the supplementary bundle? My learned friend read at page 205, read to the court the item 1, which he said he didn't quarrel with as a proposition. He had something to say about the answer given below the page, the foot of the page. But item 2 is also important. In relation to the latter, assess the extent to which such return might or might not be diminished without the claimant's continued active participation. So that the latter being that attributable to the return on his capital. So it was acknowledging that there could be, in a given case, a case where their shareholding is less valuable as a result of the absence of the claimant. And in paragraph, so over the page, that is dealt with by way, as it were, of answer in the counter schedule 2. As for the future likely profitability of EMS, the defendant relies on the claimant's witness statement and oral evidence that he has built a successful business with an established reputation. Well, Lord, I won't read it out, but you can see points are made to the effect that this was a business that was going to carry on profitably. So the point was very much put, the challenge was, as it were, put down in the counter schedule. And notwithstanding that approach, my learned friend's opening note, which I quote at page, in my skeleton argument, at page 11 of my opening note, of my skeleton.
Page 11 of your...
My skeleton, my lord, and it was in the opening note, which we've had a look at. Argument at trial, Roman 1, claimant's opening note, focused on C's primary case, which was the whole of C's income from the business has been and in the future would have been earned income. And then I refer to the secondary or alternative case, which my learned friend has mentioned to the court today and is not pursued, which would have been a challenge to the approach adopted by Mr. Justice McClellan in ADSET as a matter of principle. And further down in the skeleton, in the defendant's opening note, again the point was taken, paragraph 18, quoted in my skeleton, the defendant accepts that if the absence of the claimant from the business due to his illness and premature death has an impact upon it, then such impact, insofar as it reduces the value of his shareholding and the dividends from it, which remain in his estate, as well as his lost net salary, should be factored into the lost year's calculation. The difficulty is that the claimant has not put forward such a case, and his evidence to date provides no basis for an assessment of any such impact. My learned friend referred to Mr. Forth's report for the defendant, which
Yes.
he said proceeded on a conventional multiplier-multiplicand basis.
Yes.
But he didn't, Lordship may have picked this up anyway, didn't take the court to what was said, this is tab 11 of the supplementary bundle, what was said at paragraph 303.10 on page 295. He says, on this basis, I'm uncertain as to whether Mr. Head can, within his lost year's claim, recover the entirety of his and arguably his wife's salary and shareholding on the basis of the principle established in Asset and Waste, as his shareholding will be inherited and an income stream will continue to flow therefrom. Indeed, rather in this instance, it may be necessary to look at what replacement costs, if any, the family business may incur after Mr. Head's death as a basis of claim. However, I consider that that is ultimately a matter for the court to determine.
Yes.
And in the next paragraph, he says, in the context of such potential replacement costs, it would appear to be the case that Mr. Head's current duties will be undertaken by his family following his death in order that they retain control of the business. On this basis, presumably, any replacement costs will be those incurred to replace current family duties which are now undertaken, for which there will be no time when his duties are subsumed. And 3.12, I await discovery of evidence pertaining to such potential replacement costs and reserve the right to prepare further calculations upon receipt of the same. And so, Lord and my Lady, the position arrived at by trial very clearly on the basis of the documents put forward by the defendant in the defence and the counter-schedule, and indeed in Mr. Forth's statement, is that there are other ways of doing this. We're not seeking to shut out the claimant from what we would submit would be a proper approach in the case where this clearly isn't a one-man business in which he was doing.
Of course, it's not a one-man business. Nobody suggests that it is. It's a business with a multi-million-pound turnover and some employees.
Yeah. Well,
I don't follow the point. It makes the calculation much more difficult than in a one-man business.
Well, my lord, to pick up my lady's analogy, this is on the spectrum between the conventional one-man business, the man on a bicycle with a ladder and a bucket, and the massive business that may be wholly privately owned by an entrepreneur who set it up, who can retire to Monaco.
But the effect of the judge's judgment is that you end up in the latter rather than somewhere in between.
Because the claimant has chosen, notwithstanding these promptings in the defence and in the counter-schedule and in Mr. Forth's report, not to advance any claim on what we say is a proper basis. And had that been done, there may have been other questions to be asked in relation to the evidence. For example, my learned friend gave the example of the family giving away shares to recruit a replacement manager. He doesn't quantify how that might be done. But if that had been the case presented, then we might have wanted a valuer to give evidence to tell us what those shares are worth. We might have wanted a recruitment consultant to tell us what the market rate for someone like Mr. Head would be if you were to employ them without any shareholding in the company, but at a proper salary, proper remuneration package. And that was the invitation that was being made. We weren't trying to shut out the claimant, but the claimant chose.
Seems to me you were. I mean, everyone agrees that the distinction, the lost year's claim must be for the lost earnings from labour as opposed to earnings from investments.
Well, my lord,
Your case seems to be that if somebody has a massive shareholding in the company which he founded, then the value of his labour is zero, or at least his salary.
my lord, we've never said that. We have said, and your lordship says all agree, my learned friend has never accepted that position. He has always said, you look at what he would have obtained from the business, and you say that is what he loses, less some living expenses.
Yes, of course, that is what he says. And he says it, I'm not saying it's right, but if I understand the case, is he said Mr. Head was effectively a 90% shareholder in the business, if you
Yes.
if you follow Ward
Ward
and Newell or whichever the case it was. Therefore, his income from the business was 90% of the profits of the business
Yes.
after the employees had been paid.
Yes, I accept that. But
And he says that that is all earnings from the business, and you say, well, that isn't fair because the business is not entirely it's not a one-person business in the sense that he's the only person doing any work, like the man.
it continues in being.
Yes.
Yes.
So it may be that the answer is that you can't simply say that the income from earnings is 90%, but the judge seems to have said, well, we can't say it's 90%, that's the only claim presented, therefore it's zero.
The judge said, my lord, that there are other ways of doing it, but the claimant, through his legal representatives, has disavowed any such different approach. And
It's a pleading point, but
No, it's not. Well,
it's essentially it's a pleading point. Your proposition appears to me, at least, to postulate that if you want to make a claim for lost earnings from labour rather than investment, you not only have to plead the claim at its highest and say, this company's my company and I'm entitled to 90% because that's the value to me of the earnings from it, but you also have to plead the sliding scale. Alternatively, if I'm wrong about that, you can look at it from the perspective of the cost of hiring a replacement, and here's a valuer's expert report which says that the value of the shares would be X, Y, Z, or alternatively I might have to put it on another basis or another basis. But all you have to plead is the principle, and the principle's there.
well, but exactly what we invited them to do. But the problem is that the court also needs some evidence, or some argument as to how one goes about it. My Lord Justice Bean said, well, he owns 90% of the shares, therefore, after the salaries are paid, that's what is the value of his work. It's not, with respect, quite right, because, of course, a business, particularly where the profits have been ploughed back in, the dividends are the fruits of the capital, the labour, and the management, all sorts of factors, and the goodwill.
Well, that's why it seemed to me, on first looking at the papers, that the likely answer was somewhere between 90% and 0%. But you're saying, well, the judge was never asked to calculate that, so it's like a pendulum arbitration, 90% or 0.
Well, for very good reasons, my lord, and she was sympathetic. Can I just take you to parts of the judgment to make good that point? Your lordships will be familiar with it, but it is important to bear this in mind. The paragraph 6, she describes the dispute, the substantial dispute. And paragraph 8, she says, the issue is this: is it a relevant factor in arriving at the lost year's calculation that a significant part of Mr. Head's earnings, namely his dividend income from the shares, is likely to survive his death? And paragraph 10...
That question, that formulation seems to me to beg the question.
Yes.
Well, it's asked a question, and then at paragraph 10, Mr. Head, in other words, through his counsel, says no and distinguishes this case from Madison West on the facts. which he says support his claim for a full recovery of his earnings from EMSL, subject to an appropriate deduction for living expenses. So there is no doubt that she was presented with what we've called the all or nothing case. And I entirely accept that it's not attractive to take pleading points, and your lordships, I hope, will have noted from the judgment that I did accept that before Judge Clarke in closing submission.
You gave her two, at least two, if not three, position points in the judgment.
I did.
She records that, but nevertheless, she takes the pleading point herself and comes out at 0.
No. Well, with respect, she takes a point about the evidence, the state of the evidence. That's the problem. That she had no material. It would have been entirely speculative on her understanding of the evidence. Can I take you to a little bit more of the evidence, because it is quite striking. Mr. Stanbury's report, to begin with, in a supplementary bundle.
Yes.
At tab 10. At page 256 of the bundle, he describes the sales history, and he summarises the results over 6 years and 4 months to August 2018. From 270 customers and projects. In 3.09, he says there are 42 customers that over the period have generated sales of £50,000 plus. The top 10 customers have each generated £400,000 plus. Over the page, 2 customers, Strood's, a specialist construction refurbishment contractor, and Clinton's have generated sales of 3.5 million and 2.5 million respectively. Tops Tiles, Culver Valley Building Services and William de Ferrer's School have generated 905,000, 767,000 and 611,000 respectively. And he quotes Mr. Head's witness statement saying that with Clinton's cards, they worked for them for 22 years and serviced all their heating and ventilating issues at 400 of their stores. And the evidence before the judge, as she recorded, was that the servicing work was all done by subcontractors across the entire country. Mm-hmm. Mr. Head was entirely management at this stage, no longer on the tools, and they had a number of permanent employees. And the accounts show substantial subcontractor and employee wages. And then at 311, Mr. Stanbury says, on the basis of the above analysis, it is clear that EMS has a significant, loyal and consistent client base, that it continues to grow, resulting in a rising sales trend. In the 4 months to August 18, there seemingly had been a fall in sales, the reason for which may be related to MH's illness. And that's one of the passing remarks to an effect of his illness on the performance, although Mr. Forth had other reasons for saying that's not correct. And at 4.05, in fact, just to complete that point, he says there's no, he hasn't calculated a past loss of earnings because it's not clear whether his absence from the business through illness and medical treatment has resulted in a downturn in EMSL's financial performance. And then he shows that in paragraph 407 that the sales had reached not far off £4 million in the year ended 30th of April 2018. And he says, as analysed above, this rise in sales arose from a diverse, loyal and consistently supportive customer base. This increase in sales year on year has been mirrored by the year on year rise in net profit before tax. And 4.11, he does say a little bit more about Mr. Head's illness.
Yes.
But it was late in the financial year. And so he comes to a conclusion in 4.13 as to the likely expected annual profit before tax of £580,000, which was a figure that the judge accepted in preference to Mr. Forth's slightly lower profit element.
And do you accept that that is the figure which he projects there would have been if Mr. Head had continued to be running the company?
Well, my lord, on that question, which is I'll come to in a moment, which is ground one, Mr. Stanbury acknowledged that he had never been asked to advise on the basis of what difference it made, the absence of Mr. Head. And so while my learned friend says they were asked to write reports on a but-for basis, in fact, they weren't asked to write reports on any particular basis. They were just simply analysing the company results to date. And apart from
I know, but as you've been taking us through it, I thought it was a convenient time to find out whether you accept that the exercise which this accountant did was to project what the profits would have been if Mr. Head had continued.
Yes, that was what he was doing. But the point I was making to your lordship was that he wasn't saying, on the contrary, anything about the position, given the fact that Mr. Head would no longer be there.
No, he wasn't asked to do that.
He wasn't asked to do it. That's all I meant. So yes, I entirely accept he was analysing results to date, and there was an issue as to whether there was a, if you average it over the last few years, it was unrealistic because of a very large £1 million contract from Stroud's. In fact, at trial, Mr. Head gave evidence of another £1 million contract that had just been secured with a company called Theatre, Mercury Rising. And at the trial, Mr. Stanbury said, yes, given that information, he couldn't see there was actually any fall-off of sales up to now, up to the date of the trial. So that's the nature of the company. And we then look at what the learned judge said about the evidence before her at paragraph 15 of her judgment. First of all, she says that she had watched, and not simply read, the transcript of, she had watched the video evidence of the Mr. Head giving evidence on commission. And she then refers in 16 to the fact that she also she heard further evidence from him at the trial. It was fit enough to give evidence.
Yes.
At paragraph 26, she describes the business, which is based upon the evidence she had. And we do say, the court should bear in mind, this is effectively an attack on a fact-finding exercise by a judge.
No, it's not, Mr. Kemp. I don't think there are any facts which Mr. Steinberg has drawn, findings of fact, which Mr. Steinberg has drawn our attention to, which he rejects. On the contrary, he adopts many of them.
Well,
which findings of primary fact?
I didn't say primary fact. My learned friend is now contending for a secondary fact-finding exercise to be conducted by this court, which effectively builds upon what the learned judge had for her and what findings she made, and then says, here is a formula which we're going to apply to the loss.
That's not an appeal against the fact findings.
Well, it is, because the learned judge, having reviewed the evidence, and we come to it later, having said that she didn't have the evidence before her on which she could make a finding, that is her secondary finding of fact, that she couldn't do. There was no evidential basis for a Blaymire type award or a jury award, as it were, for the loss. So we say that is a secondary finding of fact, and the judge shouldn't be, this court shouldn't be second-guessing the judge on that. On the, to continue with the judgment, she describes in paragraph 26 the business, and I've already referred to some of it, but the contracts were with some pretty impressive customers, the NHS, local councils, government bodies, large retailers, and so on. So entirely a tribute to Mr. Head, he had developed this from scratch and had some very substantial customers. In paragraph 30, she describes the role of Mr. Head and his two sons. They had been working for the company for some time and made directors before Mr. Head became ill. In paragraph 36, she describes the philosophy or the business policy which led to the retention of considerable profits. EMSL has historically not paid out all of its profits. Mr. Head has chosen to leave in EMSL profits which are not extracted from the company by way of dividends declared and paid or directed salaries. Those go to improve the net asset value of EMSL, so she's addressing that point. He explained in oral evidence that the financial stability of EMSL is a key part of his management strategy, and accordingly EMSL carries no indebtedness beyond trade debts. There was some evidence from Mr. Head that he got into trouble in a past recession with some borrowings, and from then on he vowed never to borrow. And so that means, of course, the profits go back into the business. They're an investment in the business, which increases its ability to produce valuable dividends. That's how businesses work, particularly businesses which are dependent upon large numbers of subcontractors or employees or plant and equipment, as opposed to the personal attention of the proprietor. You've seen that Mr. Paragraph 41, Mr. Head acknowledged his sons were cut out for continuing the business. And then in 42, she does discuss the issue of the likely profitability of the company in the future. Mm-hmm. So this is not a top. And she says in 42, Mr. Head said, business is very good, we're reliable, have a good reputation, and recently we picked up a contract from Merrill Barracks, and so on. She gives details. Preferred contractors for Colchester Hospital for 7 years. Ending, business is good, we're full up until Christmas at least, there are no market issues at the moment. And that was his witness statement. At trial, he gave further evidence. This is paragraph 43. He talked about the Mercury Rising Theatre refurbishment contract, which had been secured worth over £1 million over 12 months. And he said the forward work order book is brilliant. And in paragraph 44, she says he confirmed in oral evidence that he doesn't fear for the company in as much that he trusts his sons, thinks they're capable and has no fears, for example, of EMSL going out of business, but he sees the accelerated timetable for handover to his sons from that which he otherwise anticipated as introducing uncertainty about EMSL's profitability in the future. Mrs. Head says she does fear for the profitability. I'm just pausing there, my lord. One of the problems in a case like this is that even if, as we say it should have been, the case should have been presented on the basis that the court should have the material or the evidence on which to form a view as to how the profitability might be diminished and how that would therefore feed through to Mr. Head's shareholding. One of the problems is that this was a case of accelerated handover rather than a handover that was never going to happen at all.
Yes.
And so in a case like that, if one is acting for the claimant, we would say the proper approach would be to say, you hand over suddenly, without warning, to sons who thought they'd have another 10 years and have you, their father, available for assistance, consultation, and so on, and keeping in contact with clients. And so I put to Mr. Head, well, it's every parent's fear. They don't trust their children, but you've got to let them do it. And if that is what the loss is, there is this tapering effect because it's the accelerated handover. And as I think my Lord Justice has been said, they may take a bit of time to find their feet. So it isn't simply a case of saying, what is Mr. Head worth as a managing director? Clearly more than the salary he was paying himself, we accepted that. And therefore, one continues that, as it were, on a conventional multiplicand basis. One has to, and we accept it, this does require some imaginative thinking by the court, and that's why we said it may be a Blamire type case, by analogy with Blamire. That it's really the damage done by this accelerated handover and the loss of the opportunity to make plans and to act as a guiding mentor for the sons in the meantime. And so the learned judge was, in those paragraphs dealing with the evidence before her, was clearly alive to the issues about profitability and the possibility that it had been damaged by, or would be damaged in the future, by the premature departure from its management of Mr. Head. And then when one comes to the factual findings, well, you've looked at paragraph 73 of the judgment, and I, in my skeleton, do point out that the part that is objected to, which is the reference to the agreement of the opinion of the expert forensic accountants, more likely than not, the profitability of VMSL will not diminish. If one reads that with the earlier part of the initial part of the paragraph, which my learned friend said, when asked about it, I think said he couldn't quarrel with as a summary of the position. The paragraph, the sentence which is objected to, in fact makes perfect sense. One could delete the words, "I accept the opinion of the expert forensic accountants." One could delete those words, and the conclusion that it's likely that the profitability will continue follows from what the learned judge has said in the earlier part of the paragraph.
Well, you may be right about that, but so what?
Well,
so what? What does that tell us about what was earned, what would have been earned by Mr. Head had he lived?
well, it doesn't. That is the problem. The judge didn't have the basis for a calculation. She had merely presented to her Mr. Stanbury's calculation of the whole of the income from the business, dividends, salary, so on, and Mrs. Head's dividends, the whole of the income, and it was presented to her as the loss, less the living expenses deduction that has to come off. That was presented to her. And one does ask rhetorically, what is the judge supposed to do in those circumstances? And moving on, in paragraph 74, just this dealing with this point about the judge apparently misunderstanding the evidence, we say she clearly didn't misunderstand the evidence, because if one goes to paragraph 121, subparagraph 1, she says, in terms, the experts have not been asked to and have not turned their minds to any claimant for diminution in value of profitability of the EMSL, although they could have been asked to opine had such a claim been pleaded. And it's in that context that in Roman 3, she makes another observation about the likelihood of the profitability being maintained, because there are two quite separate points in contention. One was that the challenge to the proposition that this was effectively a one-man business, and the contrast was being made with a case where the injury to the proprietor effectively brought the business to an end. That she was responding to that, and in paragraph 117, that's exactly what she's dealing with, where she refers to my comment about a one-man business incorporated for tax efficiency reasons. So one has to read her comments about the likely profitability against the fact that both on the evidence presented and implicitly in the accountant's reports, because they don't say anything different. After all, they knew why they were being asked to advise. They knew that Mr. Head had a terminal illness. Implicitly, they were saying this is actually a business that has legs of its own, and it's therefore a profitable business.
Are you going to take us to Mr. Forth's report later? If so, I'll wait. But I'd like to look at it with you at some point.
Yes, well, it perhaps is a good moment.
Yes.
Mr. Forth, the difference between Mr. Forth, apart from that passage, it's tab 11, supplement. The difference between Mr. Forth and Mr. Stanbury at trial was a narrow one, which was how you do the weighted average for the 3 years up to April 18, and whether the Strood's contract, £1 million Strood's contract, was a one-off. Mr. Stanbury
This
said...
is as to past profits.
Yes, exactly.
And in the end, the figure of 580,000 is agreed.
Well, actually, I think Mr. Forth in evidence said that yes, because at that stage we had Mr. Head having given evidence about this new Mercury Rising £1 million contract, so there was evidence of yet another contract of that sort. So to that extent it was agreed, and so I'm not sure one gets a great deal from looking at the report itself, other than the passage I've already taken the court to about a possible way of doing it, which is by valuing the cost of replacement services.
Can you help us with the schedules to Mr. Forth's report, which prior to today I couldn't read because they were in such minute type?
Well,
We now have page 332 at least in large.
yes, that's actually the joint statement.
Oh, yes.
It's
right.
it's Mr. Forth's restated figures.
Thank you.
My lord,
What's the significance of this document?
the very little. The only difference between option 1 and option 2 is whether you treat Mrs. Head's shareholding as his. And that's why he comes to different figures.
I'm so sorry, my fault. 332 is Stanbury's
Yes,
calculations, which gets...
that's right. He revised them slightly.
4.4 million. Then 334 is Mr. Ford.
I think it's Mr. Ford's, but it's merely a restatement. I think probably the same as before. And the reason he comes to do two different figures is purely because of the allocation of shareholding issue.
Yes.
And so there's nothing as a matter of methodology between them. They are both simply saying, if he's lost the whole lot, then this is how you would calculate it, which of course begs the question. So one has to be careful about complaints about the judge saying something about what her understanding of the forensic accountants. And in any event, for reasons I've already put before the court, it's irrelevant on the case that was being presented, because as the claimant wasn't presenting the case based upon a diminution of profitability, necessarily there wasn't. It wouldn't have been relevant. And my learned friend made this clear in his closing submission, whether and to what extent there had been, or might be in the future, a shortfall on the profits as a result of Mr. Head's absence from the helm of the business. The judge did make a comment about this in her reasons for refusing permission to appeal, because if a judge is said to have misunderstood the evidence, one way of dealing with it is to draw it to the judge's attention. And at tab 11 of the appeal bundle, Judge Clarke said, because my learned friend handed in, I think, an additional document, was exactly this point, misunderstanding of the expert accountancy evidence. And Judge Clarke said on page 128 of the bundle, ground 1 appears not to be well founded, as the decision was not based on a mistaken assumption that the experts had agreed that the profits of EMSL would continue undiminished after the claimant's death. The court noted in para 120 of the judgment that no claim for the diminution in profitability of EMSL had been made. And in para 121, the expert had not been asked to or turn their minds to any claim for diminution in value or profitability of EMSL. They were asked to quantify by way of estimate of the likely future profits of EMSL, although at the time they were a short way apart, and so on. And she ends, Mr. Stanbury's evidence in his report was that EMSL showed a rising sales trend, and this was bolstered by the claimant's evidence at trial. Since the report, business had improved further, and the forward order book was brilliant. There was therefore no evidence. Now, one always has to be cautious of a judge trying to justify their own judgment, but it's not to be overlooked that the judge was presented with this and did not accept that she had made a mistake, even though she may have in one place, and I would say one place only, phrased herself, phrased it slightly inadequately by referring to an agreement of the experts. We say it comes to the same thing. The expert didn't comment on loss of profitability, so whether or not they agreed about the future is neither here nor there. The question was there evidence on which the court could act? It needn't be expert accountancy evidence. It might be the evidence of Mr. and Mrs. Head, for example, themselves. Was there evidence on which the court could act so as to say that there is a proper basis which is fair to both claimant and defendant on which I can make an assessment of the extent to which not only the salary, which obviously ceases, but the dividends will be reduced in the future. And that was the problem that the judge was confronted with. What we have now is, as I hear it, with great respect, options being kept open by my learned friend. I notice, if your lordships look at the my learned friend's replacement skeleton argument in the appeal bundle, tab 3, that at paragraph 82 on page 42 of the appeal bundle, under the heading Alternative Bases for the Claim, we have this: the judge, having dismissed Mr. Head's claim for loss of income, appeared to be troubled by this result. And he quotes paragraph 119, the court would not be happy to send Mr. Head away. That was my observation. And then it goes on. This is a little difficult to reconcile with the judge's conclusion that the value of the lost year's claim was nil. If both method and calculation were correct, Mr. Head had sustained no loss and there was no cause for such unease. Paragraph 84, in any event, paragraph 120, the judge stated, and then it's quoted, there are a number of potential claims which Mr. Head could have but has not pleaded and for which he does not contend. Those are potential claims for 1, loss of profitability of EMSL and or loss of value in EMSL arising from Mr. Head's illness and premature death, and 2, the replacement cost of employing additional staff required for the same reason. Then my own friend Skeleton continues, the appellant's position, as it was at trial, is that on a conventional approach at least, these claims were not open to Mr. Head. My lord, we say they clearly were open. It's a shorthand for saying the loss that he or his estate would suffer as a result of the reduction in profitability. It's not a claim by the company, we entirely accept that.
They're not, with respect, mirror images of one of the other. That one may have a bearing upon the measure of the loss. So in order to be able to determine what part of the dividend income is properly referable to his toil and strife and what part is investment, one needs to work out whether there's going to be a diminution in profitability and what sort of a hole he'd leave. But it's not actually a claim for the loss of value or the loss of profitability. And likewise, the replacement cost of additional staff, when you might value his contribution at the cost of bringing in a troubleshooter. But that's not the same either. So they're a starting point, aren't they?
Milady, I entirely accept that. And this is a shorthand. And the court was addressed on this issue. And the point was put, and for example, it worked in relation to Mrs. Head's salary when we accepted that she was paid above market salary. There was an issue as to how much. The judge made a finding more in my own friend's direction than mine, and the result was that you then restate the figures, the company figures, by putting that extra salary back into the business, and therefore it provides a little bit more in the way of dividend income for the, or rather profit, to be distributed. And we accepted, as I've already pointed out, that she should take account of retained profits as if they'd actually been distributed. And so that the whole, although the learned judge talks about it in that way. She was very much alive to it, and one can see it from some of the exchanges in the transcript.
Well, she may well have been, but the trouble is it doesn't leap out from her judgment that this is some kind of esoteric shorthand for a claim for loss of income. It looks as if what the learned judge is saying is that there are alternative ways in which he might have put his case which do not relate to his loss of income.
And we haven't looked at the judge's findings on issue 2 yet, which is the position of whether Mrs. Head's dividend and/or salary should be treated nationally as part of Mr. Head's earnings. But I'm struck by 93. Satisfied that Mr. Head's real loss of earnings or earning capacity includes 90% of EMSL's profits after directors' salaries and corporation tax, subject to a deduction equal to the value of Mrs. Head's contribution.
Well, the Lordship has to see what issue she's dealing with under that heading. She's dealing with specifically issue 2, which is at paragraph 779, whether and to what extent Mrs. Head's dividend or salary should be treated notionally as part of his earnings. And so all she's doing at this point is saying, before I get to the question of loss, let's decide what the baseline is. So if, for example, this had been a one-man business, as in Ward and Newell's itself, where the business did fall off as a result of the injury to Mrs. Ward in that case. If it had been a one-man business, then I think she says, and we challenge this in the respondent's notice as a matter of law, but the learned judge says, well, then the loss is, I would look at the whole of the 90%, not simply his formal shareholding. She's not dealing with the question of loss at that point.
No, but reading through, if on receipt of the judgment, Mr. or Mrs. Head, as it were, read through to 93 and stopped there, they think, oh, good, my Mr. Steinberg's whole case is going to be accepted, that Mr. Head's real loss of earnings is 90% of the net profits of the company minus something from Mrs. Head's contribution. And yet, when the judge goes on to issue 5, which is the one which really matters, she comes to exactly the opposite conclusion. Very odd.
My lord, she's dealing with an issue which precedes her finding of whether there's a loss. That's all she's dealing with at that stage. So perhaps she should have said, if and insofar as there a loss of earnings, then I'm going to base it upon 90% shareholding. But that's clear enough, and of course the opening passages in her judgment make it clear what she's doing. And
you say that what she meant was Mr. Head's real earnings or earning capacity, rather than loss of. That's what you say she.
Yes, it might
should have said here.
It might have been better expressed. I accept that, my lord. But one does have to. This isn't a statute being interpreted. One has to look at the heads of argument that she's dealing with in succession, and she's dealing with the Ward and Newell's point, and that alone at that part of the case, because and which was effectively a point of law, because we didn't dispute the evidence. We had nothing to contradict it. The shareholding was set up for tax efficiency reasons and so on. Mrs. Head did have a role, but she received a salary for that. And so the one then comes to, I think I've dealt with the judge's findings on the basis of the evidence before her, and I've dealt with paragraph 121 of the judgment. And then when one comes, I've already effectively covered ground 1 in that it's a complaint that the judge misunderstood the evidence. But the problem is that if the judge had said correctly, the accountants haven't addressed the question of the future with Mr. Head no longer at the helm. In what sense I ask rhetorically, would she have been in a different position when coming to decide whether there was a loss? After all, accountants, whatever their expertise, are not soothsayers. They wouldn't really be permitted to opine about, unless they had some specialist knowledge of the market, to really say much about what would happen in the future. There may be some other sort of expert one might want to call about market conditions. I'm not sure what sort, but there may be other experts who can give evidence. But an accountant, a forensic accountant, is with great respect, a number cruncher. He's not.
Well, then how would you assess? How would you even begin to go about assessing what, how much of the profitability was attributable to the hard work of the entrepreneur, and how much to the investment value?
Well, one way, and this is what Mr. Forth was hinting at in his report, would be to say, let's look at what this company, the board of directors, would have to do if they said, we need someone of this caliber to replace Mr. Head. We go to a recruitment consultant. What will we have to pay, either in share options or salary, pension, all the rest of it, to get a person of that sort? And that provides a proxy, or provides some evidence of the damage done effectively to the company, and therefore indirectly to Mr. Head's shareholding, by the inability of Mr. Head to continue. My learned friend draws comfort from the fact that I conceded that Mr. Head was clearly paid less than the market value of his services, which I did. But that was not, that is not another way of saying that all his income from dividends represents the value of his services, for the obvious reason that if all goes well in establishing a business, you work hard at it to begin with, you establish the business, you create the goodwill, you invest in the plant and machinery, you employ the staff, you train them up, and you have a business which you hope to provide you with an income in retirement. And therefore, the fact that that Mr. Head, who had ploughed back in the family profits, as it were, back into the business, investing in it, was able, therefore, to achieve profits of $580,000 a year or so before directed salaries and so on, is both a contribution, is a tribute to him, and a reflection of the fact that his efforts over the years had paid off. A lot of those retained profits relate to his past effort.
Yes.
And they are not lost. They've been put back in.
That's right.
So, and my lord, apart from what we say is the absolutist position which the claimant seems still to take before this court, with a fallback position which isn't quite explained, we can't see what more we can do than to say that the court might well want to help this the claimant out in another way, based upon an assessment of the evidence overall. But it's up to the judge to decide, looking at the evidence overall, whether there is the material on which to do anything. Is it a case of making bricks without straw, or is there something one can build on? In other words, if this was a jury trial, would the matter have to be withdrawn from the jury, or could they be asked to say, well, there's evidence on which you can form a view? And that's the difficulty that we respectfully say the judge was in. And it's right that she says that in the end, in paragraph 125, in these circumstances where a risk to EMSL's profitability is neither pleaded nor evidenced nor argued, I make no such award. That's after considering whether the fears expressed by Mrs. Head, in particular, are such that there is the material for her to make an award. And your lordships haven't been given, still today, any idea as to how such an award could be constructed, it's something less than the 4.2 million, which simply represents all of the profits and salary that would have been enjoyed had Mr. Head been there to enjoy it.
Other than Mr. Steinberg's 10%.
I'm sorry, my lady.
Other than the 10% discount suggested in the replacement skeleton argument.
Yeah, well, that is suggested, but that is what I asked rhetorically is that based on. One can talk. We have no idea what if a company or a hedge fund or whoever who wanted to take over this business, what they would regard it as worth, and to the extent to which they would look at Mr. Head's sons and say, well, I'm afraid we don't trust you to carry on with this business, but we'll put in X, we know he's good at it. We simply don't have that sort of evidence. And simply to say, well, let's effectively have 90% of the losses, when the probability is, because of the evidence that was before the court, that this business will continue, is to ask for an award, which we say is plainly not holding the balance between claimant and defendant, which is what the court is required to do. This isn't one of those cases, as one has in fatal accidents cases, where because of statutory disregards of benefits and so on, one can arrive at an award which is sometimes a great deal larger than the loss actually suffered. And so we now, it's clear there's no dispute about the legal principle, what Pickett was deciding. Pickett was a conventional case of loss of earnings during lifetime, and the question was whether it continued, whether there was a claim beyond the expected death of the claimant. It certainly wasn't saying anything more than that, and I've already made the point forensically that it can't be right that a lost year's claim is larger than a lifetime claim. If anything, it's going to be smaller because of the saving on living expenses. Yeah. And so that really deals with, we say, ground one, that whether or not the learned judge misunderstood, and we say she couldn't have misunderstood the position because she says in terms, in paragraph 121, that the experts have not been asked to comment on the future profitability with Mr. Head no longer at the helm. Ground two is the apparent inconsistency with Ward and Newell's, and I've dealt with that in my skeleton argument. There are two quite separate points. Ward and Newell's itself was a case where the evidence was that the business was falling off. One looks at, I think I've quoted it in this skeleton argument. It's sufficient, but I may come back to that if I need to on the respondent's notice point. But at this point, this ground, an inconsistency with the judge's finding on Ward and Newell's, there's no inconsistency because the Ward and Newell's issue is, first of all, should there be a notional reallocation of apparent entitlements to share of the profits. It says nothing about that once you've done that proving a loss. That's the next issue. And so there's no inconsistency. Even if the judge was right to reallocate Mrs. Head's shareholding as being effectively beneficially owned by Mr. Head, that still begs the question as to whether he has suffered a loss, his estate has suffered a loss as a result of the, we would say, a diminution in the value of that shareholding, either by capital value or reduced dividends.
Well, if that's the right question, then of course what you say is right. My problem is that issue 5 by the judge, the judge's crucial issue 5,
yeah.
It seems to me she's not asking the right question. The right question is what personally has Mr. Head lost? What has he lost in earnings?
Yes.
In making a distinction in which Mr. Justice McCulloch puts very well. By dying, a man loses the opportunity to provide for his dependents and others out of future earnings from work. He doesn't lose the opportunity to provide for them out of income earned by capital of which he dies possessed. And the question in this case was what would have been Mr. Head's earnings from work, less living expenses and so on.
Well, it's what would have been his earnings which have been lost.
Yes.
And paragraph 70 of the judgment makes it very clear that Her Honour Judge Clarke had no illusions about what she was about. She quotes, she refers to Adshead and West, refers briefly to my learned friend's secondary argument, which was not pressed in the case, and says, towards the end of that paragraph, I agree that whether a focus on earned income and income derived from capital assets and a true assessment of losses in the lost years will be fact-specific, as this case demonstrates. As I have set out above in my judgment, the real distinction being drawn by Mr. Justice McCulloch in Adshead and West is not between earned income and income from capital, but from income which is lost on death and income which survives death. And therefore, my acknowledgement that Mr. Head was paying himself well less than the market salary was an acknowledgement that it was tax efficient to sell his services, as it were, to the company by taking more of the fruits in terms of dividend than he could otherwise have justified. In other words, if Mr. Head had not been a shareholder, he could have said, well, you're not paying me 45,000 or whatever it was. This is what I want.
Sure.
And that's why Mr. Forth said, that's another way of looking at it, what's the replacement cost? And so the learned judge was not, in any sense, caught up in a false dichotomy between dividend and salary, or earned income and unearning income. She was focusing on what would in fact be lost by whatever tax-efficient vehicle it might have been delivered had Mr. Head lived to him. That is all she's doing. And if my learned friend had acknowledged that therefore, because of the features of the business which I've referred to in Mr. Stanbury's report, which effectively say that this is a business where the work is delivered by subcontractors, employees. It's a nationwide business. It's a large-scale business. If that had been acknowledged, therefore that there must be some residual value in these shares, then that at least would provide the starting point for a discussion, at the very least, as to what one might sensibly say is the loss that can be attributed to the sad early demise of Mr. Head. In other words, what is the element of added value that he continues to give? One of the problems with these cases is that when one moves on the spectrum from the window cleaner with the bucket and the ladder and the bicycle to the blue chip company, one moves away from the point at which the entrepreneur who set it up is actually still needed. They don't. This is not to deny their value, but there obviously comes a point where, as they've been adding, investing profits, training up staff, obtaining contracts, they are gradually able to, in theory, entrepreneurs, it's never in their DNA to do it, but in theory they could sit back a bit.
Yes.
That's the point. And that's the point that was never addressed by the way in which it was put by my learned friend. It was the all or nothing case. And if it had been a different case, we might have approached it with different evidence, but we didn't. And so when the learned judge does conclude that she can't assist, as it were, notwithstanding the reluctance to send claimant away with nothing under the lost year's head, she was entirely acting entirely on the basis of the way in which the case had been presented and the evidence before her, and should not be criticised for doing so. I have set out in my skeleton argument at some length, I fear, but it saves going to it, the submissions in closing, page 3, paragraph 8 of my skeleton. First of all, by me going first in closing submissions, and which referred to the that we're not responding to a case based upon loss of an expectation of future company. And my learned friend's response to it, which he referred to two red herrings. And one of the red herrings was that when I said we had been waiting for some evidence about the effect on the business of the absence of Mr. Head, and my learned friend said that is simply not relevant. And the calculations carried out by Mr. Stanbury and Mr. Forth are sufficient because they're projecting what the claimant would have lost. Now, I accept that if Pickett had decided that lost year's claim is based upon what you are no longer there to enjoy, then that would be right. Because there is a view, the House of Lords might have gone down this route, that it's irrelevant. The estate is still going to enjoy the fruits. You're not there to benefit from it. But Pickett and the citations, I think, that are in my skeleton argument, Lord Wilberforce, for example, makes it clear that it's what the lost year's calculation is doing is focusing on the surplus from his earnings after his living expenses, which will be available to the claimant to do as he wanted with, whether it's to benefit his dependents or leave to a charity or whatever, the surplus. And of course that's, by definition, still available to his estate.
And is it always, are the living expenses always taken from the salary in the case of somebody with a large investment income?
Well, it's a variable, but Lordship may have noticed that the living expenses weren't taken, I think this is right, from the retained profits in this case. My learned friend will correct me, but I think the learned judge said a 45% deduction instead of the usual 50%.
Yeah.
Harrison Empress Motors deduction comes off only the salary and the income that would have come to him, not the retained profits. So in fact, it's a lower. The judge was focusing on what he would have received, as it were, in his current bank account.
Right.
So it isn't really a 45% deduction. It's rather lower altogether if the overall loss was as intended for by my friend. If I could just very briefly take you to what is said in Pickett to make the point I've just been making.
Yes.
Authorities Bundle, tab 3. And the problem was that the earlier case of Oliver and Ashman had said that effectively a loss of earnings claim does not go beyond the life expectancy. You just get a conventional award. And Lord Wilberforce, at page 21 of the bundle, 146 of the report, at letter C, said, it seems therefore strange and unjust that his claim for loss of earnings should be limited to that 1 year, the survival period. He shall recover nothing in respect of the years of which he's been deprived. So it was a case where the plaintiff had an existing loss of earnings in his lifetime, and the only issue for the House of Lords was, does it come to a sudden halt? Is it limited? And it's a page 24 of the bundle, paragraph D, Lord Wilberforce says this, is he not entitled to say at one moment, man with the existing capability to earn well for 14 years, the next moment I can only earn less well for 1 year, and why should he be compensated only for the immediate reduction in his earnings, not for the loss of the whole period for which he has been deprived of his ability to earn them? And he says to the argument that they are of no value because you will not be there to enjoy them, can he not reply, yes they are, what is of value to me, not only my opportunity to spend them enjoyably, but to use such part of them as I do not need, for my dependents or for other persons or causes, which I wish to support. If I cannot do this, I've been deprived of something which has a value, a present value.
Yeah.
So that's the point about the surplus, which is available for him to do what he wishes to do with it.
It's a surplus over and above his essential living expenses.
Yes, although those living expenses will include an apportioned part of those shared with his family, unlike the Fatal Accidents Act. So it's a slightly higher deduction than the Fatal Accidents case. And then page 27 of the bundle, Lord Salmon, again, it's making the same point just below letter B. Suppose, in the case I postulated, the plaintiff's action for damages for negligence comes to trial 2 years after he first became incapacitated. This is assuming a 5-year loss of earnings, effectively. He would obviously be entitled to compensation for the remuneration he had lost in those 2 years. And then between C and D, I do not accept there can be any justification for limiting this compensation for the earnings he would have lost in the 3 years immediately following the trial. So again, it's focusing entirely on losses. And at page 29, Lord Salmon at letter C to D says, I think in assessing those damages should be deducted the plaintiff's own living expenses which he would have expended during the lost years, because these clearly can never constitute any part of his estate. So again,
Yes.
it's a loss to the estate. I may be making points, I'm sure
Well,
I'm making points that are not
I don't
controversial.
think this is in dispute.
No, it's
Is
not.
it? The judge's 45% figure is not challenged here.
No, that's the deduction. That's right. But I'm still apparently faced with an argument that the lost years is the full 4.2 million, which, if right, means that the House of Lords in Pickett were going further. I'm not sure how far that is pressed.
Well, this is a very, very unusual case that as when I used to be involved in these regularly, which was a very long time ago, the standard lost years claimant is a wage earner,
Yes.
working in the construction industry or the heating industry or whatever, and the calculation of what has been lost is not generally very difficult once you've read Pickett. This is much more difficult because Mr. Head was not a standard wage earner.
It's more difficult, but it's made more difficult by the way in which, building on Pickett, apparently, my own friend's argument is, well, we can have the lot, as if the burden of proof somehow shifts to us to say, well, no, a lot of this is going to survive, and that's
Well,
the
I think
problem.
it's based on the evidence that's relied on that he was essentially so pivotal to the company, and the company was him, as his wife said, that once you take out of the equation the salaries that are paid to all the other people who are working under him, it's essentially equating the position with your example of the one-man band who incorporates himself. That's the case put at its highest.
Yes.
I think
Well,
that's the way that it's been
Yes. Well,
framed. You may be right that that's putting it too high.
Well, it was based upon the profits before directors' salaries, I think.
Yeah.
I think I'm right in saying. So you've got, if one looks at Mr. Stanbury's report with some very small print, one sees page 272 of the supplementary bundle. One needs good eyesight for this, but these were the results up to 2018. There was a later figure, but we see that, for example, under costs of sales, wages and national insurance are 395,000.
Yeah. So the wages come out at that stage.
And subcontractors 27,000, and therefore this isn't. If to take forward your ladyship's example, an approach to the value of the management had been, well, what would you do if you didn't have any of these subcontractors? Then the answer is you wouldn't be making these profits. So you go around in circles to some extent. Whereas, and that is why the more one moves away from the one-man band business, the more difficult it gets, I entirely accept. Because it cannot be right that this business has no value without Mr. Head. It's a tribute to his achievement that it does have a value, we would say. But we would expect...
But the irony is, Mr. Kent, that if the business crashed and burned because of Mr. Head's demise, it would be very easy to calculate what the loss was.
Yes.
But because he's made a success of it, he ends up with nothing.
Well, my lady, that's true.
It may be right as a matter of law, but it does seem a little counterintuitive.
Well, I think I think it may be even in Pickett. One of the members of the Lordship says that the law of tort is not concerned with punishing the tortfeasor. It's a question of loss. And the fact is that if people who save money and invest their proceeds for their retirement are able to, or would have been able to retire on the fruits, then they may not suffer a loss. Whereas the more spendthrift might have had to go on working till they're 80 without that benefit, and then there is a loss. That's simply the way in which every case is case specific. And all we are saying is that there is a burden of proof on the claimant. We entirely accept that the courts are not going to be too pernickety about this, and that's why I mentioned Blamire in closing submissions, and the judge considered that as a proxy or analogy of the way in which these cases can be dealt with. If you talk about a jury award, but simply for my learned friend to say, well, let's have everything except perhaps 10% because the shares have some 10% residual value. Well, how do we know that? With respect, how do we know that someone isn't out there prepared to pay a great deal for these shares if they're on the open market? And that is the problem with simply. That is the danger of overstating your case, with great respect.
You mentioned Blamire. Do you have any submission as to what approximate level of damages the judge should have been thinking in terms of if she had gone down that road?
Well, I can't remember whether I gave the learned judge a figure.
I couldn't find one.
But my submission would be, if asked, is that in order to, on the state of the evidence, because there was no evidence that this company was suffering, as at the date of the trial, the court would be simply approaching it on a very broad brush basis and should not award anything more than, it may get into 6 figures, but nothing much more than that. Because it is perfectly open for the...
Sorry, but you keep coming back to this phrase. There's no evidence the company was suffering at the date of trial. That is not the question, surely.
No, but the question
is whether Mr. Head had lost future earnings.
Yes, but in the common case, the loss will already have occurred. So you would have a past loss of earnings.
Yes.
If Mr. Head, for example, had been injured and unable to work at all for a year, then you would have a pattern established.
Yes.
Now, fortunately, of course, for him, he was able to continue to some extent. And Mr. Stanbury did make a passing remark about the impact on the business. He said he couldn't quantify the loss that was in the joint statement. He said there may have been some impact from Mr. Head's illness. I can't quantify the loss. Can I just make that good? If
you showed it to us earlier, I think.
I think I did. It's also in the joint statement. I think it's... sorry, yes, it was in the paragraph 4.2 of the joint statement. JS, that's Mr. Stanbury, further notes that this fall in sales.
Page, sorry.
Page 328, supplementary bundle. This fall in sales has continued. So by the time of the joint statement, they had another year's results through to December 2018, or management accounts. JS notes that this period may coincides with Mr. Head's mesothelioma diagnosis and ensuing treatment regime. This reduction would likely result in a reduction in profit available for distribution for shareholders and therefore a loss to the claimant. JS acknowledges this loss but is presently unable to quantify the same. In the next paragraph, Mr. Forth takes a different view because he says it's all to do with the one-off Stroud's contract, but leave that aside. There's a passing reference, and Mr. Stanbury can't quantify it, and that's a lifetime loss.
What can you summarise the reason for the the fact that Forth's calculations are 1.4 million or 836 million on the one hand, and we know what the basis of Stanbury's calculations are.
I think
what are the points on which Forth differs from Stanbury?
I think it was only the profit before director salary. He said 545,000 per annum. Mr. Stanbury said 580,000. It was a very narrow difference. And it was a question of what sort of weighted average you took from the previous years. And Mr. Forth then conceded, having heard Mr. Head at trial, this new £1 million contract that perhaps Strude's contract was not a one-off. And so effectively, I'm not sure whether he entirely agreed, but the judge found that she preferred Mr. Stanbury's figure. And I think that's all, apart from this reallocation of Mrs. Head's shareholding, which was gave rise to option 2. That was all that was between them. And so, to take up your lordship's question about what the loss would be in a case like this, to date, Mr. Stanbury couldn't quantify any loss. Understandably, I'm not criticising him or criticising anyone. Mr. Head was still doing his best to carry on with the business. And so the judge doesn't have, as it were, a starting point which she can then project into the future, as you do have in many of these cases, and did have to enter the realms of speculation. And she wasn't assisted by someone coming forward and saying, well, if I was buying this company, I'd need to pay a lot for a replacement manager because these customers need constant attention. Or I've analysed in detail what Mr. Head was doing on a day-to-day basis, and I think this has a value, which I would, again, if I was buying the company, I would put that sort of evidence that would provide some material. And if the reason I say it might get into 6 figures and not more is because, and only just into 6 figures, is because it is not the function of the court just to, because it's all very difficult, to come up with a figure plucked from the air. There still is required in this jurisdiction, a logical, evidential basis for a judge's conclusion as to the measure of a loss which has been proved. And that's what Lord Scarman was saying in Gamble and Wilson, and it's why in lost years cases with very small children you don't project loss of earnings. It's too speculative. And Lord Scarman was saying, well, if the evidence is there and it's cogent. In contrast, if the matter is speculative, then and he talked about, he says, if sufficient facts are established to enable the court to avoid the fancies of speculation, even though not enabling it to reach mathematical certainty, the court must make the best estimate it can. What we're questioning is whether, if the learned judge had come up with a figure, would we have been coming to this court saying this was entirely speculative? What was it based upon? That I think is the problem. And one's very reluctant for a defendant to take refuge in burdens of proof, but there is still a requirement to both bring forward a case which is based upon some evidence and to define it clearly, rather than simply saying, as my learned friend says effectively, you start with the entirety of the loss of earnings and dividends, and then somehow you work back from that, because that's to reverse the burden of proof. I think ground 3 is, we say, a misunderstanding of what the judge was doing. Ground 3 of my learned friend's skeleton was the judge erred in including only Mr. Head's salary and not the dividend income or retained profits. But I hope I've made it clear that we weren't, and the judge wasn't making any bright line distinction between salary as such and dividend income. The judge was focusing on what is lost. That's what she says in paragraph 70 of her judgment. And we entirely accept that Mr. Head might have paid himself more. My own friend says, well, he could have paid himself, he didn't give a figure, but let's say 500,000 a year, and we couldn't complain. Well, with respect, we could have done. We could have said, that doesn't represent the value of your labour that you've lost. It works both ways, just as the judge readjusted Mrs. Head's salary to reflect a market value. In a case where, in contrast to this case, where the director's salary is well above what his worth reflects, then that wouldn't represent his loss. And one would look at the overall position. In any event, you can't pay yourself more than the company is able to provide, so there's a limit to that process. That really is the nub of our that's our answer to ground 3. There was the learned judge in paragraph 70 makes it very clear that she understands this isn't applying labels. It's not a question of labels, it's a question of reality and substance, what has been lost. Ground 4 is, with respect, the same point as I think I've already covered. We accept that the loss is personal and that insofar as EMSL may lose from the absence of Mr. Head, that's only the starting point. But it doesn't enable one to claim something which isn't a loss. It still has to be a loss. The ground 5 I've dealt with, that's a complaint about what the learned judge said in towards the end of her judgment at paragraph 37 of my skeleton argument. I respond to that. The judge wasn't treating the testamentary disposition as somehow determinative. She was merely illustrating the point, picked up from Lord Wilberforce in Pickett, that if you have a surplus from your earnings, which you nevertheless lost as a result of your life being shortened, then that would have, if you'd lived, that would have been something that would have been open to you to leave. The judge simply said, this is again the point, that the earnings don't dry up. She says when he dies or becomes unable to work, the earnings dry up and cease, is the example given. And she says at the end of paragraph 117, dividend income would survive wherever he leaves those shares by testamentary disposition. So she was simply making the point that it doesn't matter where they go, they survived for his estate. The new case being put forward, I think I've covered this to some extent because it isn't clear from paragraph 82 of the replacement skeleton for the appellant. It is far from clear what is now being asked for. The replacement, paragraph 89, the cost of a replacement, and there's reference to the Fatal Accidents Act cases where indeed the cost of a replacement was used as a proxy for the loss by the defendants of a business. For the first time, notwithstanding my learned friend saying that it was a red herring, paragraph 94, my learned friend says the measure of loss in Mr. Head's own claim, however, would not appear to be the cost of replacing the services. He personally lost the income. I'm sorry, not for the first time. He's saying again, it's not to be done by the cost of replacement. So he's still resisting the idea of that as some sort of proxy. And that's the sort of evidence that the court might have been able to act upon in determining the extent to which the profits would have been lower for Mr. Head, or will be lower for his estate, because those will be additional costs sustained by the company. And so we say that there is, unlike Mrs. Head's own the value of her services, where the accountants did give some evidence of what would be a market value, we don't have anything which is a piece of evidence that the court could act upon that it identifies, even if in a rough and ready way, what the costs of a top-class manager taking over Mr. Head's role would be. And so if that had been provided, then that might have been fed into the calculation. Lord, subject to any points about those grounds, additional points, there is my respondent's notice, which my learned friend has briefly adverted to.
Yes,
it's a very short point because it doesn't concern the facts or the findings. My learned friend took you to Warden Newell's. Can I just start off with Kent and British Railways Board?
Can you just refer us to the respondent's notice?
Oh yes, that's it's tab 6 of the appeal manual. And the meat of it is at page 76. It's curiosity that the standard form of notice of appeal doesn't really cater for this situation, because it requires you to seek to uphold the judge's decision on additional grounds, whereas this is actually an argument that is put forward if and only if your lordships allow the appeal, and then it's a question which arises contingently on that as to whether the notional reallocation of Mrs. Head's shareholding was correct. But that's the point being made there. And in the authorities, the first case is tab 9, Kent and British Railways Board, quoted in my skeleton, and this was a partnership with an agreement with the revenue that the profits of the business should be 60% to her husband and 40% on the plaintiff who was injured. And the master had accepted that it should be 100% of the profits should be recovered, the loss of profit should be recovered. The Court of Appeal decided that the reality of the situation, relying upon Section 24 of the Partnership Act, was that they shared the profits equally. It wasn't rebutted by any agreement with the revenue. And Sir John May, who gave the main judgment, with which the other members of the court agreed, said, first of all, at page 181 of the bundle, a third of the way down, there was no formal document, contract or partnership deed between the plaintiff and her husband. And at page 183, in the first full paragraph, although we were shown a number of authorities on the point, it is, in my opinion, trite law needed, I think it should be needing, no authority, that in the circumstances of the present case, the respondent's husband had no claim in law against the appellants. They owed him no duty of care which they breached. So that's the starting point, that there isn't a claim by the partner in respect of his own loss. From this, I think it must follow that in law the plaintiff cannot recover the full amount of the loss of takings of the business. To allow her to do so would effectively afford her husband a right of recovery, whereas, as a matter of law, he clearly has none. In my opinion, hard though it may seem, it is necessary carefully to analyse the nature and legal incidence of the relationship between the plaintiff and her husband and the business, to use a neutral phrase. Doing so, I must conclude that the plaintiff and her husband carried on the tea shop and the bed and breakfast business in partnership. They carried on the business together with a view to making profit, and he then quotes the Partnership Act and continues, subject to the effect of the arrangement with the revenue of the 40-60 split of the profits, the conclusion to which one must come at this stage is that there was an equal partnership between husband and wife. And the conclusion is that that presumption isn't rebutted, as Sir John May continues in that paragraph. And so what we gather from Kent and British Railways Board, that it is a hard matter of analysis of the legal rights of the partners.
As a matter of law, doesn't the case stand for saying that you have to look at the reality of the situation? See the end of the paragraph beginning subject to the effect of the arrangement.
Yes.
Albeit that on the facts of that case, the reality of the situation was as per the statute, equality.
Yes, but the reason one looks at the reality is because if you have a partnership with no partnership deed, then the Partnership Act has a starting point of equal shares, and then you look at the reality to decide whether this partnership should be treated as an agreement for something else. And so that's what's going on in a partnership case where there isn't a partnership deed, and that's because the court is carefully analysing the nature and legal incidence of the relationship between the plaintiff and her husband.
But you're saying that if we look at the reality of the situation in this case, we have to ignore the findings of the judge and stick with the legal position as to ownership of the shares.
Yeah, for a reason I'll come to. But as I've made clear, I'm not quarrelling with the findings of the judge as to what the family intention was. And so that was authority which was binding upon this court in Ward and Newell's. And when one comes to see what was happening in that case, we've already had a look at it. I'll find the reference. Tab 11. My learned friend has referred the court to judgment of Lord Justice Henry at page 198 of the bundle, letter F. Mr. Ward was a workaholic and so on. And then in the next paragraph, Lord Justice Henry goes on, the judge was satisfied that without Mr. Ward's illness, the group's business would have been more profitable than it had been, and in addition to that loss of profit, in certain regards, it proved more expensive to carry out on the group's business because of the need to hire additional personnel. I mention that in passing because, of course, when my learned friend makes I think it's his ground 3, that there's a mismatch between the judge's finding on the Ward and Newell's point and her finding on no loss. The point is that this was a case where there was a loss, either in the form of a falling off of business or an increase in expenses as a result of the injury. And then at page 207, letter C, Lord Justice, and this has again been read by my learned friend, Lord Justice Henry refers to Kent and British Railways Board and adopting, and he says, between C and D, and in adopting the presumption of equality in default of agreement under section 24 of the Act, he expressed himself as looking at the reality. So he is applying, Lord Justice Henry is acknowledging that the court applies the requirement of the Partnership Act, and you're looking at the reality. It's a contract between parties, an agreement they've arrived at, and what is it that, objectively speaking, they are taken to have agreed if you don't have a partnership deed which tells you.
Well, it's not just that. If you look at 201, letter G, he identifies what the issue is. The issue before us can be encapsulated in the question, what was Mr. Ward's real loss of earnings and or earnings capacity? So that's what the court is focusing on, and it comes to the conclusion that notwithstanding that there are 4 partners, in fact, his real loss of earnings is 50% and not 25%.
Absolutely, but he does that because he concludes that in reality, the partnership was other than was as agreed with the revenue. That was the truth, and what was rejected, I think it's in this case, was an earlier decision of Mr. Roger Bell, Queen's Counsel, who then was, that effectively said it was a matter almost for the discretion of the court. Whereas Sir John May is making it clear it is an analysis of the legal incidents. And so if there'd been a falling out and the partners were suing each other in the county court, what would the county court judge have done about it? And the county court judge would, in the absence of a deed, have had to say, well, let's look at what you've agreed, who's working in the business, who's the sleeping partner, and so on. And this is the result. And so and this is made clear in another case we rely on, Neal and Jones Motors, paragraph 13, tab 13, where this court, or Justice Ricks gave the judgment, said the main judgment, they weren't in a position in that case to make the adjustment that was sought. And paragraph 41, Justice Ricks says, what is the significance then of a finding of partnership in this case? It is as follows, and then it refers to Canton British Railways Board. But I've no idea why all this is underlined. I think that's
I was wondering.
It wasn't intended. This court held that where one member of a two-person partnership, there a husband and wife partner, was injured, the injured person can only claim for losses to that partnership to the extent of that person's interest in it. That rule was there applied even to the case of so domestic and family a business as a husband and wife partnership in the running of a bed and breakfast property. Contrary submission founded on the earlier case of Anderson and Davies, Mr. Roger Bell as he then was, that in such a context, if all the income went to the support of the family concerned in what was effective joint husband and wife endeavour, it was not possible in reality to separate the losses. That approach was specifically rejected in Kent. So it didn't allow you to say, well, it's a sort of family loss. So the injured plaintiff could claim it all. And that is a series of authorities, starting with Canton British Railways Board. Necessarily, the subsequent authorities who were bound, where this court was bound by the decision in Kent, could only distinguish it if necessary. The question, therefore, is what is the legal analysis of the rights and obligations of the various protagonists. And so when you come to a corporate structure, or rather, when one comes to the learned judge's finding on this point, she actually concluded in paragraph 91 was this. And as I've said, I'm not challenging the evidence on which precedes this and the findings. 91, therefore, although Mrs. Head is legally entitled to the dividends, which are paid in respect of both the A shares and B shares, by virtue of the fact that they are registered in her name, in reality I'm satisfied that Mrs. Head considers herself to be holding those shares to the direction of Mr. Head. It seems likely that would have continued for so long as the marriage subsisted. There is ample evidence before me that this is a long and happy marriage with no discernible likelihood of failure. Unlike the partnership cases, where there was no partnership deed, so the court had to do its best to determine what were the partnership shares, as an objective matter. Here, the learned judge is not doubting that Mrs. Head was the legal owner of the 45% shareholding, but she said that she considers herself to be holding them to the direction of Mr. Head. What, I ask rhetorically, does that mean? Is she a trustee? Is he the beneficial owner of those shares? Did they form part of his estate? Would they have formed part of his estate? We respectfully say that there isn't really room for this. There might be a trust instrument. There might be a situation where the court could conclude that the shareholding is beneficially owned by the injured person. But it's not enough to say, this is a family, they're all friendly, they get on well enough. She's not going to stand in the way of her husband directing.
So finding that she's holding this money as a nominee for fiscal purposes, which is on all fours with paragraph 42 of Neal and Jones. What was said about how the court decided things in Ward and Newell's?
Well, lady,
direct analogy.
The difference, of course, is that there isn't any legal. There's no starting point with a legal entitlement, except the Partnership Act 50/50 starting point.
Well, that's a pretty good starting point, isn't it?
Yeah.
Yes, in those cases, exactly. And so in those cases, you start with 50-50, which is why, I think it was...
In a company shareholding point, you start from a point that each 1% share is a 1% share, and
Yes.
the judge held in this case that this is not so.
No, with respect, it's not a starting point. With the Partnership Act, the starting point is 50-50 in the absence of a partnership deed. If there had been a partnership deed saying these are the shares, then it would be different. And the point that was, I think it's in Kent, one of them, the agreement with the revenue, which of course was the whole purpose of this adjustment, was regarded as not enough in itself to overcome the 50-50 presumption.
Well, we wouldn't know whether, I don't know whether we know whether there was a partnership deed in Ward and Newell's, but it would be 25, 25, 25, 25, wouldn't it?
Well, we know it was 50-50 between him and another partner. That's right. I think it was...
But the starting point would be 25% each.
Yes,
and the
exactly.
court said no, it's actually 50-50 as between the husbands, because the wives are mere nominees.
Yes. Well,
The approach of Lord Justice Brooke at paragraph 54 seems to be nothing to do with Partnership Act, but simply the reality of the situation is that one of them contributed the labour and virtually all the capital, and the other contributed his skills and business, and therefore the reality was 50-50, but not because of the Partnership Act.
I'm not sure which case your lordship's referring to.
Neil and
Neil.
James.
Yes, but the difficulty with that is that it's acknowledged that Kent and British Railways Board is the authority on the point. So unless there was a different approach, because Sir John May makes it very clear, it's an analysis of the legal rights.
So you say that it's a binding ratio of Kent and BRB, that where the situation is shareholdings in a company, that's conclusive, and Mrs. Head must be taken to have a 45% real interest in the company.
I do say that. It's never been part of his estate, and therefore she has... It would be claiming a loss, if, contrary to my other submissions, there is a loss provable in relation to the dividends and so on. She would be claiming a loss in respect of someone else's injury. I mean, it would be the classic case, which is not permitted by Kent and BRB.
So if there is a formal trust deed which said I'm holding these shares on trust for my husband, you take a different position because the legal formalities say that's what's happening.
I think I'd have to, lady, yes.
So if the reality is that she is holding them as a nominee and the judge has so held, why is that different? Why do the formalities make a difference?
Well, the judge has so held only on the basis of of the evidence as to why they had this structure in the first place.
Yeah.
And the position only becomes relevant in relation to proving a loss in this case. And
as it did in the partnership cases. But in the partnership cases, the court says you look at what's the reality is whose income is it. Speaking of myself, I don't understand why you don't look at the reality as to whose income is it if it's a company.
Well, the distinction, and this is made clear in Ward and Newell, is that the partnership was terminable at will, so any partner could dissolve it. So if, for example, Mr. and Mrs. Ward had fallen out, and whichever one was the sleeping partner had said, I want my share, the answer would be, well, sorry, I'm terminating the partnership.
Well, if she's holding the shares as a nominee for him, and there's a falling out, he could call on her to hand over the shares to him and register them in his name. Same difference.
Well, I accept that, but what is the evidential basis for that, other than that
The evidence of Mrs. Ward.
Well, well, she said she owns the shares, and she's got them, as is often the case. She has property in her own name, which derives from the successful efforts of her spouse. Not an unusual situation, but that doesn't make you a nominee for the spouse.
But if Mr. Steinberg's case is right, one should be looking at the loss of value of Mr. Head's earnings
why does this matter? Because on any view, Mrs. Head was not earning, save for the contribution as quasi-office manager, which the judge has made findings about, which aren't in dispute.
Well, the answer is that if a loss is proved in the sense that the absence of Mr. Head from the management of the company feeds through into a diminished flow of dividends or profits, those profits might be going to not only to Mrs. Head, they might be going to anyone else who owns the shares. Might have been given to a charity. Might have been, some of the shares are owned by their sons. But the law doesn't permit that loss to be recovered in these proceedings. That's the short point. It is not, as Part J, Mr. Roger Bell, Queen's Counsel, it's not a case of the family income being sufficient to found your claim for loss of income, loss of earnings. And so what we do say is that although the learned judge says Mrs. Head regards herself as holding the shares to the direction of her husband, we don't dispute that that's what Mrs. Head said and that's what Mrs. Head meant. That doesn't translate into a legal obligation. If there had been some dispute between husband and wife as to who owned what, then there would have had to have been a rather different analysis as to whether she was a trustee for her husband or it was a gift effectively to her.
The judge found that it was a long-standing marriage which was going to last. Suppose that that hadn't happened and that you hypothesise that a few years down the line they might have broken up. Well, wouldn't Mr. Head then have, if Mrs. Head on this hypothesis had said, well, I'm hanging on to my 45% shareholding, Mr. Head would have said, well, in that case, I'm winding up the company and starting a new one, and I will devote my energy and efforts to the new one. And then where will you be? So why is it very different from a partnership terminable at will?
Well, because this is I mean, obviously anyone can act, as it were, in a way which is self-damaging. I mean, just as an injured conventional personal injury case, someone could say, well, I'm fed up with this. Although I could continue with this business, I'm going to wind it up. But the defendant might say, you're not mitigating your loss, or whatever. So that would be the answer to that. But insofar as a dispute between them is concerned, this entirely notional dispute, then I think Mrs. Head would have referred to the presumption of advancement.
It's not like the boarding house case, where Mr. and Mrs. Proprietor are jointly running the boarding house, and it needs both of them to keep the place going. It's not like.
No, it's not like the dancing partner case where you can't dance on your own.
Certainly not.
And that was the fatal accident case, of course, where there was no claim by the partner. Yeah. But these are all entirely accept your Lordship's observations. But what we don't accept is that the judge can move seamlessly, effectively, from saying, well, I understand the family arrangement and why it was arrived at and its tax efficiency and so on, into effectively a finding that losses, let's say they are going to be sustained to the business, losses that in fact Mrs. Head will sustain because she retains that shareholding, presumably to this day. That nevertheless, that should be factored into her late husband's estate's claim. That is the point, and I don't think it's one that can be developed much further. It's safe to say that it isn't a.
Did it very well. Thank you.
I'm sorry I've taken so long, but unless there are any other matters.
Thank you very much, Mr. Kent. Very grateful to you. Mr. Steinberg.
My Lord, my Lady, on the final point, I simply submit that the judge's reasoning was impeccable, that my learned friend's point is precluded both by three authorities from the Court of Appeal and the judge's findings, and I had no more on that point. And my Lords, you've heard from me at length, my Lady, you've heard from me at length this morning. I have nothing else to add unless you'd like me to address you.
very much. We'll certainly no need to repeat anything. Any questions? Thank you. We're very much obliged to both of you. We will, of course, reserve judgment. There is no possibility, I think, of any of us composing a judgment until January. If it should come to pass that any agreement is reached, particularly prior to January the 4th, would you very kindly let us know? I did have that happen in one or two cases at the bar, but if that doesn't happen, then we will produce our judgments and send them out to you in the usual way for typos and for factual corrections and so forth. And it won't be necessary for anyone to attend on the handing down of the judgment, which in any case might be remote, given present troubles. Thank you very much.
Harry, for not adding to the heat in this room by lying at length.
I think I said enough.
Is that it for you this time, or have you got more?
No, I've got a couple of things to do, but it's probably my final appearance in a real life ball. How about you? When you
Yeah, this is well. I'll be. I've got to be not in court. I reckon. I hope. I have a food taster in the form of Ian Harvey. He tasted my water as he came in.
I was obliged to.
Oh, thanks. Thanks very much. Be back. We have no play.
No, no.
Trick is
every now and then sort of coming around when she's sort of year 11 in the classroom and things like that. That's not ideal. Right.
oh.
Yeah.
Nice. I'm good.
What is it doing? It's nursery in court. It's for assessment from the birth. It's hard around here. it's Lucy here, Usher in court 63. Just to let you know that the judgment has been returned. Bye.
Yeah.